Hello and welcome to this video on advising executive directors and shareholders on the termination of their employment. I'm Carol Davis KC from Littleton Chambers and I specialise in high-value employment disputes. In this video we're going to look at issues that surround the termination of employment for a senior executive, including the impact on directorships, shareholding and top tips for achieving a good settlement. There are several key things to think about when acting for an employee who is also a director and a shareholder on the termination of their employment. The first thing is there a reason for dismissal that has been given, and if so, what is it? Secondly, is it a summary termination or a dismissal on notice? And if notice has been given, how is that notice to be served? Is it to be spent in the garden? Or has a payment in lieu of notice been made? And if there has been a pay in lieu of notice made, was that made pursuant to a valid and effective pylon clause? Consider also whether there are any post-termination restrictions that bite on termination of employment. If there is a notice period, what are the employee's obligations during the notice period or the restrictions on what he or she can do? And really fundamental to all of that is having a good understanding of the contractual relationships that govern the employment relationship and the directorship status. So that will require you to have a look at the service agreement and any side letters or amendments, any LTIP plans that there may be or bonus schemes. Any shareholders agreement, share scheme rules, share awards, share options, and also the articles of association and any other constitutional documents relating to the company. Knowing the reason for termination is really important because it will help you identify, of course, any potential claims that are open to an employee, whether that be a wrongful dismissal when notice wasn't given or full notice wasn't given, or unfair dismissal, or another statutory claim such as discrimination, whistleblowing, or redundancy. Secondly, it will help identify whether there are any processes that should be followed prior to termination, and thirdly, it will help you determine the level of appropriate settlement. I just want to focus on three particular areas, and the first is summary dismissal. I think it's fair to say that summary dismissal without any payment of notice or notice being given is generally rare in the case of senior executives, and it's only really legitimate if there is very clear evidence of a serious misconduct or some other repudiatory breach of contract on behalf of the employee justifying dismissal. More commonly, notice will be given and sometimes a pay in lieu of notice. However, if there is a summary dismissal with a pay in lieu of notice, do check whether there is in fact an enforceable pay in lieu of notice clause in the service agreement, because if there isn't, then that will be in itself a breach of contract. And there are two consequences of that to think about if acting for an employee. The first is that the employee has the choice whether to accept the repudiatory breach and bring the contract to an end, or to affirm the contract so that it continues. And whether or not the employee is going to want to do that really depends on whether or not there is an impact on the termination package. So, for example, if there is a bonus payment or a payment under a long-term incentive plan that kicks in on a date after the date of the summary termination, then in those circumstances the employee may be well advised to affirm the contract and continue the contract so payment can be made. The second thing to think about, of course, is post-termination restrictions. Where there has been a fundamental breach of contract by the employer accepted by the employee, then the post-termination restrictions fall away. Bear in mind, however, before you advise your client to skip off to a competitor, that there may be post-termination restrictions in the shareholders agreement which continue to bite for as long as the employee remains a shareholder. The second area to consider is garden leave. And very often in the case of a senior executive on a long period of notice, the employer will want the executive to spend all or part of their notice period in the garden. And there are two advantages to that really for the employer. The first is it can buy space and time to allow for negotiations. The second thing is that during the period of garden leave, the executive will remain subject to the express and implied terms of their service agreement, including those relating to confidentiality and fidelity, which can help prevent competition. From an employee's perspective, there isn't an inherent right to work. However, if the executive is a director, then he or she continues to have influence in their role as director because they continue to be entitled to attend board meetings and also to receive documentation relating to the business of the company. That brings me to my third area of focus, directorships. It's important to remember that termination of employment, even if it's summary termination for gross misconduct with no notice, does not automatically bring a directorship to an end. So have a look at the service agreement and the articles of association to see whether there are any provisions within those documents which provide for the resignation and termination of a directorship. It may be that the service agreement includes a power of attorney, which allows another individual to sign resignation papers and related documents on behalf of the director who refuses to resign. To be valid, however, the service agreement must have been executed as a deed. And bear in mind also that if the termination of employment has been in breach of contract, the authorities are unclear as to the extent to which a power of attorney will still be valid in those circumstances. If there is no valid mechanism in either the service agreement or the articles of association to allow for the removal of a director, then the business is either going to have to negotiate the ending of the directorship or is going to have to fall back on the provisions of the Companies Act 2006, which allows for a director to be removed from office by ordinary resolution of the members in a general meeting. But that will require 28 days notice to be given. And of course, from the employee's perspective, they're likely to want to remain a director for as long as possible because that gives them the right to attend board meetings, receive company information, and therefore retain some influence in their position as a director. Where the director who's being terminated is also a shareholder, you're going to have to consider the impact of termination of employment on any shareholding. And of course, for that, it is vital to have a good read of any shareholders agreement, any option letters, award letters, and scheme rules. And the important things that you're going to need to consider are what happens on termination to any share options or shares already held. In the case of share options, can they be retained on termination or are they forfeited? In relation to options, are there vested options or unvested options? Typically, unvested options will fall away on termination. In the case of vested options, they may become exercisable on the discretion of the employer, and that may require negotiation and settlement with the employer. Equally, there may be shares already held, either on a nominee basis under the service agreement or because of options that have previously been exercised. Consider and look in the documents to see whether there is a mechanism for transfer of those shares, and if not, that will again have to be a subject for negotiation with the employer. Most share schemes refer generically to departing individuals as leavers. Now, the reason for termination will determine whether somebody under the scheme is a good leaver or a bad leaver, and that will affect how their shares are dealt with. Typically, good leavers are those who leave for an innocuous reason, whether that be retirement, a disability, or a TUPE transfer, for example. A bad leaver is somebody who leaves for poor performance, misconduct, or perhaps goes off to join a competitor. There are several things to look out for when negotiating an exit package on behalf of a senior executive. The first thing is directorship and how that comes to an end. Now, of course, the employer is likely to want that to come to an end pretty swiftly. The employee, on the other hand, is likely to want to retain the directorship and retain their influence and bargaining power for a little bit longer because, of course, for as long as they remain a director, they can attend board meetings and receive company information. You'll also want to have a look at post-termination restrictions and what wriggle room there is in relation to those. Bear in mind, however, that if there are post-termination restrictions in a shareholders agreement, the consent of any other shareholders is also going to be required if any deal is done. Have a look also at the shares, whether there are shares that need to be transferred, at the timing of that, whether there are deals to be done in relation to vested options, and again the value of those too. And any settlement is likely to be quite substantial in terms of the sum and the number of different elements that includes, including loss of remuneration, loss of office, possibly a loss of a bonus payment or payment under a long-term incentive plan, and of course the value of any lost shares. Which means it's really essential to take some specialist tax advice during the negotiations so you don't get a nasty surprise at the end when the deal is done.